All right, good afternoon, everyone. I hope you had a good lunch. We're going to start. Okay. So we're going to start. I hope the colleagues who have joined online, including the speakers, they can hear me. So we have this session on access to effective remedy. And we have two distinguished speakers who are joining in person in Dhaka. And there are 3 or 4 speakers who are joining virtually. So this is going to be a hybrid event. The format of this session is going to be like this, that I'm going to introduce briefly the session, the focus of this, and all the speakers together in one go. And then I'm going to invite all the speakers to provide reflections on a question that I'm going to pose to them. And after that, we will have some discussion based on the questions that may come from the audience, either in person or virtually, or there could be some comments coming from the speakers about each other's intervention. I want to introduce myself. My name is Surya Dev. I'm a member of the UN Working Group on Business and Human Rights, and it's my pleasure to moderate this particular session. As you know, the focus of the session is on access to effective remedy. And if you look at Pillar 3 of the UN Guiding Principles, the Pillar 3 contemplates 3 broad possibilities of remediation. First is judicial remedies. We can file a case before the courts. The second is non-judicial mechanism, where you can approach, let us say, a national human rights institution. In South Asia, we don't have a national contact point. Or the third possibility is there could be a grievance mechanism established by a company, or you may reach out to some grievance mechanism of international financial institutions. A key differentiating point that we wanted to discuss in this particular session is that, of course, if there are abuses in South Asia, you can try to seek remedies within South Asia. But can the victims in South Asia, and these could be individuals or affected communities, they also seek remedies outside South Asia. So a key focus of this is not only what we can do within South Asia, but also what options are there in terms of seeking remedies outside South Asia. And I think some of the panelists will specifically discuss those particular issues. With this brief background, let me briefly introduce the distinguished panel of speakers who are with us. I will start with the 2 speakers who are in person in this room. So on my left, we have Ms. Umpi Kulusum. She is the Joint Secretary in the Ministry of Law and Justice Division of the Ministry of Law, Justice and Parliamentary Affairs, Government of Bangladesh. So thank you, Ms. Kulusum, for joining. On my extreme left is Dr. Kamal Ahmed, who is a full-time member of the National Human Rights Commission of Bangladesh. So Dr. Ahmed, thank you for joining us. Then going virtually, we have Ms. Miriam. She is the Legal Director and the Program Director of Business and Human Rights, European Center for Constitutional and Human Rights. So as in acronym, we call it ECCHR, and this is a key institution in Europe to work for the rights of the affected communities in seeking them access to remedy. We also are joined by Ms. Sarah Hussain. She is a lawyer, Supreme Court of Bangladesh. So Sarah, wonderful to have you. We are in your country, but because of your prior commitments, you can't be in person, but glad to have you joining us online. We also have Ms. Rachel Bonner. She's a solicitor with Litigate. Litigate is anyone who is working in the space of business and human rights must know Litigate, because this is perhaps the most noteworthy law firm based in UK, litigating for access to remedy against transnational corporations. So thank you, Rachel, for joining us. And last but not least, we have Mr. Shankar Limbu, who is a human rights attorney based in Nepal, and he works on many issues, but in particular, the rights of the indigenous people. So Shankar, thank you very much for joining, and it's a pleasure to have you joining this particular session.
Thank you very much.
Excellent. So that is also a good testing of the technology, that it's not merely you can hear me, we can also hear you in the room. So thank you, Shankar, for testing that. So without any further ado, I would like to now start with Umpi. And if you can tell a little bit more about what the Ministry of Law and Justice is doing in Bangladesh to strengthen access to remedy, especially in those cases where businesses are involved in violation of human rights or polluting the environment. So the issues could be about labor rights, they could be about gender discrimination, or they could be about environmental pollution issues. So, Madam, you have the floor. Thank you.
Thank you very much. You know that Law and Justice Division is working in order to ensure access to justice for all and protecting rights of people. And legal aid services are arranging by Law and Justice Division almost 64 districts, and one judge as a senior assistant judge is working as district legal aid officer to provide legal aid, to give legal consultation, and to adjudicate the matter by ADR mechanism. Besides that, there are 2 labor cells in Dhaka and Chittagong to provide legal aid to the labor and other activists who are coming to seek legal assistance against the different industry and company and the owner of this company. And they are always try to mitigate their problem by alternative dispute resolution mechanism. So this is our opportunity to provide legal aid to the litigant people by this way. Another things are the tribunals of labor tribunal and labor appellate tribunal, you know, from labor ministry are going out, and some judicial officers from our ministry provides here as district and session judges. And equivalent judges are working in the labor tribunal and labor appellate tribunal, and they always try to adjudicate their problem by alternative dispute resolution mechanism, as they give speedy trial to them. So these are the organizational setup from our ministry, and some different issues involved with their rights, you know, which is related with awareness build-up. Nowadays, we already set up 120 legal aid clinic in the grassroots level, especially in the union and ward level, by which the legal aid officer and other supporting staffs are providing their service to aware the litigant people about their right, which is related with human trafficking and family related matters, family disputes, land disputes, and so on. So these are all from our ministry. And some digital platforms are there, which is going with legal aid services. As you know, that illegal aid service, online automation system, legal aid office management software, and BD legal aid apps in order to ensure online filing of application. Digital monitoring system is going on. And another help desk or hotline number is 16430. By this hotline number, anybody can ask any kind of legal questions which is related with their legal rights. They can put their question in this hotline number, and they can get solution of their problem. So these are all of our ministry. Thank you.
Thank you very much. Probably we can come back to you later with some more issues that might come up. But at this stage, this was useful to provide the context within which access to justice is dealt with in Bangladesh. Sarah, can you hear me? I would like to now come to you. And Sarah, you have been litigating to see access to justice for the communities in various courts. So if you can share with us your experience of judicial process in Bangladesh. So the processes and mechanisms that are there, whether these are approaching the courts or the issue of legal aid. So what challenges do you see victims find in seeking access to effective remedy? What are the barriers that you see from the practical point of view? Because something on paper is very different from what is working in practice. So if you can share your experiences on that, that will be very useful. You have the floor, Sarah.
Sure. Thanks so much, Surya. I'd like to start perhaps just by complimenting what the previous speaker from the Ministry of Law said, because I think it's important to note that in addition to the government's legal aid services, there are also legal aid services provided to workers by a number of non-governmental organizations. So, for example, I volunteer with the organization BLAST, Bangladesh Legal Aid and Services Trust, and we also refer cases to the government hotlines and to the government legal aid program, and in some cases receive referrals also from the government legal aid program. I think the difference between the government legal aid and the non-government legal aid programs are important to note, because there are many opportunities for strengthening and expanding legal aid services and information through collaborative partnerships. So, for example, the NGOs which work in this area tend to work with paralegals and community paralegals, including amongst the workers. And that provides a real opportunity to provide information to workers directly on site in the factories or in the communities where they live, and to basically link them up to the government legal aid program, which is focused around the courts. And the court premises. So it's more inaccessible in some ways, and this is the way to create the access. In terms of judicial proceedings, there is a kind of challenge in that, of course, there is legal aid and there are lawyers available to provide free legal representation, but access to the courts is challenging because we don't have labor courts in every district. There are a limited number of labor courts, and workers face real challenges when, for example, someone lives in the north of the country and they're going to have to travel long distances without good transport, without any facilities to cover their transport costs, which we provide from legal aid, but they have to also cover all of their other costs as well, and that becomes really difficult. I think the other challenge in terms of court proceedings is, of course, the notorious, South Asian issue of extreme delays. It's a problem in courts all over the world, but I think we particularly suffer from it in our region. So people can really, and we find that even where workers have the strength and the courage and resources to file claims, often they become exhausted by the proceeding and they don't really wait until the end. And that's why, exactly as the previous speaker from the Law Ministry said, that alternative dispute resolution is very important. I think we need to focus more on enabling judges to learn actually the skills of ADR. And perhaps also this is another scope, a real opportunity to again engage the non-governmental organizations that have already been doing ADR in this area for really decades now, to maybe facilitate more training for the legal community and also to initiate ADR formally in the labor courts as well. So we have it in our family courts as a necessary pretrial procedure, but it's not yet there in terms of labor disputes. There's also much more, I think, that can be done in terms of increasing access to the courts and also monitoring of cases through using digital processes. Again, there are important initiatives by the Law Ministry and the government on this. Through BLAST also we have an app called Shromik Jigasha, or Questions for Workers, through which we provide information about different forms of labor disputes and what can be how they can be addressed. And paralegals can use that to inform people on the ground. What we don't have at the moment is a way of tracking what is happening with our court cases. So we can track BLAST's own court cases, but we can't really track what is happening in the labor courts courts themselves. And there isn't a digital, it may be available to the government. It would be really interesting to hear more from the Law Ministry about that, I think. But in terms of the user or the litigant, or even for a legal aid lawyer, we can't really see what's happening in the system and how we can track a case and what kinds of delays there are and where we can intervene. So I think that's an important area. Now, just maybe lastly, Surya, if I may, I think there's another issue which is important to address, that because of certain limitations in terms of the ordinary judicial process and also limitations still in terms of our legal framework, we have in many cases had to take resort to extraordinary remedies in the Supreme Court through the writ jurisdiction, and basically through invoking constitutional protections. And in the case of the sort of major disasters we've had, for example, in the apparel industry with Rana Plaza, or with the Tazreen fire, or even actually beyond garments in other industries as well. In each of those cases, because we see that the ordinary judicial process is not very effective, and also because, as I said, the legal framework is so limited. It's still the case, unfortunately, that in the case of deaths or injuries at work, in the case of deaths at work, the basic payout for a worker is still only 2 lakhs, so 2,000, essentially about $2,000, clearly completely inappropriate. So in those cases, in fact, the Supreme Court has intervened in a number of cases to direct that higher interim compensations be paid. And there are a number of cases still pending in the courts, public interest cases brought by a host of organizations, the Bangladesh Environmental Lawyers Association, ASK, Aino Shalish Kendra, and BLAST, where we've been challenging the limit, the ceiling under the labor legislation for compensation. So those are, I think, really critical. And just let me end by giving one example of how in our domestic system, we've seen quite progressive and positive changes happening in terms of how the law is enforced. I mean, if you ask me in one sentence, what is the issue? People would tell you the law is not so much the issue, the implementation is the problem. So what are some of the examples of how implementation works? Just to give one, around the legislation the lack of legislation rather on sexual harassment and protection against in the workplaces. This is maybe an interesting example of how international law actually affects progressively and positively domestic application. So we have no specific legislation around protection against sexual harassment in the workplace. There's a sort of general clause in the labor code, but not specifying sexual harassment as such. Our legislation on violence against women also doesn't specify sexual harassment as such. As you are all probably familiar, the Indian Supreme Court many years ago in its Vishaka guidelines laid down that in the absence of national legislation, the guidelines that it provided would then have the force of law. Bangladesh then had, some years later, a very similar judgment brought by the Bangladesh National Women Lawyers Association, in a case brought by the National Women Lawyers Association, which resulted in guidelines. Those guidelines, of course, have the force of law under our constitution as well. And those have been, interestingly, followed quite. There's still many compliance gaps. I don't think one should underestimate that, but it has been followed by many workplaces, public and private. And a very interesting example of how it was used in a government department, the Department for Inspection of Factories and Establishments, which is the main inspection body under our government. Initially, we were in dialogue with DIFE through BLAST, and initially DIFE had suggested that perhaps these guidelines didn't apply to DIFE because they were judicial guidelines, they were not part of the legislation, and DIFE's initial understanding was that its duties were drawn down from the legislation only. But through dialogue, it became clear that indeed these guidelines did apply also to DIFE. And the very positive changes we then saw were that DIFE revised its inspection checklist for its factory inspectors to include the requirements from the Supreme Court guidance. And it also provided, in a very, I think, open way, invited BLAST to provide training to its factory inspectorate on how it should look into these questions, and is now, in fact, monitoring compliance with the guidelines themselves. So I just wanted to give this example to say that when you asked us the question of how do we use, what kinds of remedies can we seek beyond the region? We know we don't have a South Asian human rights mechanism or an Asian regional mechanism, but using remedies, accessing remedies beyond the region can also be by the invocation of international law through our national courts, and then working on implementation in dialogue where necessary, through litigation where necessary, with the relevant administrative bodies and authorities. And I think I'll end there, Surya, but I think the question I haven't really taken up from you is how would we litigate in terms of foreign courts, using perhaps universal jurisdiction processes and so on. I know that Miriam and Rachel will speak to that, so I won't do that. But I just think one issue for us to raise from our perspective as national lawyers and national legal aid organizations is there is a real concern about the risks for workers who are engaged in those processes, particularly I think in terms of victim and witness protection. And I think that's an issue also that for our authorities to consider and for us to be very alive to as well. Thank you.
Thank you very much, Sarah, for providing a very comprehensive but also complementary reflection on what is on paper in terms of the legal system, what are the barriers, and you highlighted also some of the solutions, that the way forward to overcome some of those issues. And I'm going to come back to some of the issues that you raised, whether this is about sexual harassment guidelines inspired by the Vishakha judgment, or you mentioned about the writ petitions, and you also towards the end mentioned about the potential repercussions for the affected communities or victims in Bangladesh if they want to litigate abroad. So we'll come to some of those issues hopefully towards the end. But now I would like to move on to the next speaker. So Kamalji, I would like to come to you now. And because Sarah mentioned about ADR, alternative dispute resolution, as I mentioned, as a possibility. So we have National Human Rights Commission in Bangladesh, and you are doing very active work in the space of business and human rights. So if you can share with us what NHRC of Bangladesh has been doing in relation to access to remedy, what steps you are taking, whether these are ADR mediation conciliation possibilities, or accepting complaints, making some recommendations, or indirectly, how you are supporting the affected communities and victims, whether it's through legal aid, raising awareness and all that. So you have the floor, sir. Thank you. Okay. Yeah. Okay. Yes, you can go there. Thank you.
Thank you, Moderator. From National Human Rights Commission, the actions we take, as a matter of fact, as a mediator for rights holders, we take our initiative in that regard. And what you have asked about Barrister Sarah's question about ADR, I'll be covering that up. And I would say that, well, in order for telling about remedying human rights abuses in the field of business and human rights, we from National Human Rights definitely try our best to implement UNGPs, United Nations guiding principles. And in that, in Pillar 3, we deal with judicial and non-judicial matters contribution to remedying abuses in the field of business. Now, the judicial remedy that is given through guiding principles, as you have asked me what we are trying to do from our organization, I would like to say that, well, the guidelines definitely highlights that states need to take appropriate steps to ensure that its legal system and national courts should address business-related human rights abuses. So it is fully judicial matter, and my colleague Kulsum has also rightly elaborated what they are trying to do. At this point, we need to remain very careful about government's activities, how to reduce legal and practical barriers so that they could prevent victims from accessing the effective remedy. That's the action that we are trying to do. That's the action our government is taking, and we are trying to help out. In fact, the judicial department is doing, and we are trying to help out. And we always raise question if there is any barrier anywhere, so that actions or rather initiatives can be taken to remove barriers. Non-judicial remedies, where there is state-based mechanisms and non-state-based mechanisms. National Human Rights Commission is one of those that is in state-based mechanism. In that, it is possible on the part of National Human Rights Commission to come into that question of alternative dispute resolution that Dr. Sarah Hussain brought in. We are working together, as a matter of fact. Her organization, BLAST, and BRAC, I know Shalish Kendra. There are some organizations, human rights defenders, with whom National Human Rights Commission has memorandum of understanding, and in the case of violation in different areas of human rights, especially in the business areas, they provide us or bring us some complaints, and we try to deal with that. Now, in dealing with that, what we do is we have our bench, and from that bench, we try to resolve different issues that, especially the complaints that are coming to us. Now, there we try to give hearing to the complaints in benches. We have two benches. One is looked after by our chairperson and another by myself, having 4 divisions in the jurisdiction out of 8 divisions in the country. And we look after cases or complaints brought in. There we find that there are some cases which are fully judicial. They have gone to the court. The case is running. So definitely we cannot take that up. What we can do is, sometimes we find that there are people who are absolutely poor and cannot run the case. So we provide them with support with our panel lawyers. We engage them and we communicate with those people that you can take full support from our panel lawyers and you can continue the case so that you can fight against the against perpetrators, whatever had been done. And now about state-based mechanism that we are dealing with as a matter of as a national human rights institution. What we do, that is in fact outlined especially in guiding principle 27 and 31 especially, and there it comes that, well, we have to create some situations so that we can go for reconciliation, mediation, we can go for some kind of discussion over there so that we can resolve some cases. I'll be giving some specific examples about that. The situation has not been absolutely supportive to us during COVID situation. I can say that novel coronavirus was not noble. It really kept sore on us, and we had been affected seriously, and lots of people lost jobs. They were left, they had to leave the organizations, and business organizations didn't pay many of them. And for that matter, we had to fight, and we had to raise voices against them, and we had to talk with different business organizations. We arranged meetings, conferences, and we had talks with Bangladesh Garments Manufacturing associations, BGMEA, BKMEA, BTMEA, all these organizations, so that they do not really cause any harm in the business places. There is no abuse of their rights. I will give you some examples of these cases. There are many examples we dealt with in our bench. As a matter of fact, today I find that I am not a lawyer, the only within the domain of all lawyers, but I'll be telling that with a background of, law degree and also as a magistrate in my past career, I have some knowledge by which we can deal with these things. There were cases like security money or the money due to the company, which was not really given. Certificates were confiscated, laptops were kept by company. Then accident happened in companies. The person lost the job, and there were deprivation on the part of those people. Then there were cases like sexual harassment in companies, especially a question raised about what is happening if somebody is outside the country, especially the migrant workers. There is in fact, very bad situation, we must say, that migrant workers, especially women workers, they suffered seriously. One of the migrant workers, she was in Saudi Arabia, and she couldn't contact her relatives over here. But later, when she got a chance to just communicate, she said that I'm going to die, please take me back. And National Human Rights Commission immediately intervened and tried to bring her back through the ministry. But unfortunately, she really died and her dead body had to be brought in. And we found that there were serious lacking on the part of the people who sent them. At the same time, there were misdealings in the place where she was working. And ultimately, the poor lady really died, and we are going to deal with that. And we talked with our embassy. Embassy continued with legal proceedings, and there was a result, I must say, unfortunately, at the cost of her life. Now that, well, in Saudi Arabia, there was a judgment. It called cases, life, for life. So death sentence has been given to that woman who was perpetrator, and her husband and her her son was also convicted for the same reason. So this is something happened because of the communication that we could maintain. Now that, well, there could be some perhaps South Asian regional human rights mechanism of NHRS might play a key role relating to rights of migrant workers, especially women and girls. We can try to do something like that, and we can say that, well, National Human Rights Commission is in a non-judicial state-based organization, as a quasi-judicial organization, is trying to do these things through mediation. But there are other things like non-state-based mechanisms, that is related to mechanisms provided by industry associations, multi-stakeholder groups, financial institutions, company. They can come up. They can, in fact, render their contribution as associations. And unfortunately, we haven't been able to see lots of initiatives taken by these organizations. Of course, the situation is much better. These big organizations, they are now trying to play a role in their organizations, but it has to be expedited. That's what I want to say. Thank you very much.
Thank you very much, Mr. Kamalji, again for highlighting several concrete cases in which the NHRC intervened and what were the outcomes and all that. Now I would like to explore the other dimension where access to remedy is at least attempted by either lawyers or other institutions outside South Asia. And here I would like to start with you, Miriam. So if you can share with us one particular case study that was led by ECCHR about, like in Bangladesh, we had Rana Plaza. So a similarly bad accident happened in Pakistan in the factory of Kick, the German company. And then this litigation was initiated in Germany. So if you can walk us through, because many people in the room may not know about the context. So why did you try to file the case in Germany? What was the outcome? Were you satisfied with it? Any barriers you experienced in trying to seek remedy? Time is limited, but we'll be very grateful if you can walk us through that particular case study so that we can learn lessons that how remedies can be sought even outside South Asia by the victims here. You have the floor, Miriam. Thank you.
Thank you. Thank you very much also for the invitation. I'm very honored to be here. So we as the European Center for Constitutional and Human Rights, we are a human rights organization that in particular uses legal proceedings to enforce human rights and to represent the interests of those persons or communities whose rights have been violated. It is our primary focus to say that we want to challenge powerful actors, and in particular powerful actors that are located in Europe and in Western countries. And as human rights are not only being violated by governments, but also by businesses, we are focusing on the responsibility of European businesses for human rights violations that are occurring abroad. So one of our focus areas is the contribution of European companies in the commission of war crimes and crimes against humanity. We are challenging, for example, arms exports from Europe to countries like Saudi Arabia that are then being used for the commission of war crimes in Yemen. But we are also challenging the role of buying companies, of brands, for example, with regards to their responsibility for human rights and labor rights violations in global supply chains. Now, on the one hand, what that is trying to do is it is really an uphill battle, because everything in the legal setup of how contracts, purchasing contracts are designed, the goal is for brands not to be responsible for the payment of living wages, not to be responsible for working conditions, fire and workplace safety, and so on. And there is exactly where the UN Guiding Principles come in, with this idea that actually businesses do have human rights due diligence obligations, in the sense that they need to consider which are the human rights risks that their business activity is connected to. In the Ali Enterprises factory fire in Pakistan, Karachi, the constellation was the following, and in my opinion is quite emblematic for how one can construct the responsibility of a multinational company located in Europe, in this case in Germany. So in 2012, in September, the textile factory Ali Enterprises caught fire and burned more or less down, as I said, in Karachi. More than 250 workers died because they were not able to leave the building due to, from our point of view, a lack of fire safety measures. There was no fire alarm system. There were not sufficient fire exit doors, and so on. Now, the facts of the case are sort of contested because allegedly the question is whether there was arson involved or not. But anyways, I think despite the fact that even if there is arson, fire safety is there to be able to leave the building. So let's assume those are the set of facts. Obviously there has been quite some litigation ongoing. There's been public interest litigation against the National Labor Inspectorate and so on and so on. But the question obviously is, if that factory had one major buyer, which is a German textile company called KIK. And if KIK, as they have admitted publicly, had been buying 70% of the production of Ali Enterprises over a course of 5 years, and is claiming in its public appearance that it does care for workplace safety, that it does social audits to verify that working conditions in their production facilities are in accordance with official norms. So therefore, the question that we have raised in a German court is to say, well, that actually a company that is so closely linked to the production side, that has such a controlling position, because economically Ali Enterprises was dependent and from this international brand, then it should actually have a duty of care to improve working conditions in the particular factory. And as they did not do so, we made the argument that KIK was actually liable under tort for the damages that workers had suffered. We were more or less, and I think my colleague from Litigate will elaborate more on the jurisprudence that Litigate has been building up. So we've been more or less using the same line of reasoning under common law, tort law, on how to construct the responsibility. The German courts unquestionably have jurisdiction over a company that is headquartered in Germany, so the jurisdictional question was not a problem. The 4 claimants one worker that survived the fire with severe health injuries, and 3 parents of workers that had died in the factory fire were the claimants. They were granted legal aid by the German courts, which says that in principle their claim is valid, and so the courts consider it to be worth going forward. The case eventually was lost on statutes, on the reasons for statute of limitations, because in the pre-trial negotiations, we had negotiated a waiver on the statute of limitation the opposing party was able to prove that under Pakistani law that is not possible, and that due to the Statute of Limitations Act that is enforced in Pakistan, the statute of limitation was 1 year or respectively 2 years, and we did not succeed in our arguments why that actually was interrupted. So you could say that in the end, the case was not successful as it did not bring the demanded compensation. But what the case clearly showed is that that it is possible to bring those kind of cases. It gave the kickoff for a legislative reform a couple of weeks after the case was dismissed in first instance. The Ministry of Development published a first law proposal to introduce a human rights due diligence legislation in Germany that actually legislates the responsibility of companies headquartered in Germany with regards to their supply chain. So basically taking up the argument we've made in the litigation. Also, what the case did, as we're in close collaboration with Pakistani trade unions and other labor organizations that were pursuing simultaneously negotiations under the ILO on compensation of all workers, not only for the claimants. I would say that sort of the strategy to pressure the brand that was until then unwilling to pay compensation under the ILO scheme, which is a voluntary scheme. But it actually did, so the case did put the pressure, in my opinion, on the company that it actually, a week after we were granted legal aid by the German court, the company agreed to pay $5 million in addition to 1 million it had paid as immediate relief into the ILO compensation fund. And it was the only brand other than in the Rana Plaza setup for the ILO compensation. It was the only brand that was potentially possible to pay into this. So so obstacles, I think I've shown, it is the question of proving law. It's obviously quite a complicated process of bringing a case from Asia to Europe. But again, what it does show, it is important to not only, obviously, but also tackle the brands that are at the one end of the supply chain, so that they contribute to delivering justice to victims. And I have to say that the Pakistani government authorities have actually paid a lot also of compensation to those victims. So it was definitely not only that brand.
Sure. Thank you very much, Miriam. That was very useful as a concrete case study that how victims can try to seek remedy within the courts in Europe and the limitations they face and the potential success that could be there. Probably we can come back to you if time allows in terms of what kind of collaboration with lawyers and civil society groups in Asia could be helpful going forward for ECSHR and whether you use that collaboration already to pursue this case. But Rachel, I would like to now come to you, and the case that I would like you to talk about is a case about Bangladesh, in fact, and the recent case where a worker got injured, and there are many other situations where the ship-breaking industry in Bangladesh, workers get injuries, or even sometimes they die or they have exposure to very hazardous substances. And then you pursued those cases before the courts in England. So if you can share again the same question, why did you try it there? What was the collaboration barriers? And the case was decided in your favor. So if you can walk us through that particular case, thank you. And you have the floor, Rachel.
Thank you very much. Firstly, I'd just like to say thank you for having me today. It's a real honor to be part of this event and speaking alongside the rest of the panel. So as Surya said, Litigate is a law firm based in the UK, and we specialize in claims on behalf of claimants in the UK, but also across the world, who've been harmed or discriminated against or their human rights abused by companies or governments. And similarly to Miriam, we're trying to hold companies and the British government to account for harms they cause around the world. And we bring the cases in the UK because we want to hold those multinationals to account and try and get the best remedy possible for those victims, so that we can both get a good result for them and hopefully have a wider impact on industries and to prevent these multinationals to continue to work with impunity and cause harm to other people. Of course, if it's possible, it would be preferable to bring a case in a victim's home country, but often access to justice is limited or the resources simply aren't there to bring these cases, which can often be very expensive and require funding. So the case, as Surya said, that I'm going to discuss briefly today is an example of one of these cases that we bring at Litigate against British companies that cause damage to people's rights and the environment in another country. So the case was brought in the UK on behalf of the widow of a Bangladeshi shipbreaking worker and has actually led to developments in the law in England and Wales, which I'll discuss shortly. I'm sure many of you are very familiar with the practice of shipbreaking, but for anyone who isn't, I'll just give a quick background. So once a ship reaches the end of its working life, the ships must be dismantled, and this can happen relatively safely with health and safety procedures enforced and processes followed to safely dispose of the hazardous wastes that are inside the ships and also to prevent injuries to workers and to the environment. And there are yards which are sometimes called ship recycling yards, which can be found in countries such as China and Turkey and across Europe, which do follow these processes to make it as safe as possible. Shipbreaking, on the other hand, is the technique used predominantly across South Asia and most notoriously in Bangladesh and India and Pakistan. And this involves a ship being deliberately beached on the shore where toxins and hazardous materials leak from the ships onto the land and into the sea. And the workers have to cut apart the ships, mainly by hand, using little more than blowtorches and ropes. So there's almost a total absence of health and safety protections, training and equipment, and the shipbreaking is considered to be one of the most dangerous jobs in the world. But over the last decade, over 70% of all end-of-life ships have been broken up using this beaching method. So the attraction of shipbreaking to a company is that it's far cheaper than ship recycling because of this cost of implementing the health and safety, human rights and environmental protections. So shipbreaking yards are able to offer more competitive prices than these greener yards, and so the ship owners are able to make more profit by using these shipbreaking yards. One of the challenges of bringing a legal case in this area, and in fact this applies to lots of our cases against corporations, and Miriam alluded to this earlier, is that the shipbreaking industry is notoriously complex and the companies structure themselves in a way that they use multiple shell companies, they change the names of and reflag the vessels to get around EU regulation and legal liability. And to avoid scrutiny in the shipbreaking industry, sales of ships are not conducted directly between the ship owners and the shipyards in South Asia, but they use demolition cash buyers who act as middlemen. And this creates some distance between the ship owners and the yards, and also puts some of the financial risk on these middlemen. So this particular case was brought against a British company, which was called Marin UK Limited. And it was brought on behalf of Hamida Begum on behalf of her late husband, Mr. Khalil Molla. Mr. Molla was a shipbreaking worker who tragically suffered a fatal accident when he fell from a ship when he was dismantling in Chittagong in Bangladesh. And the claim was not brought by Mrs. Begum against the Bangladeshi yard or Mr. Molla's employer, but we brought the case against the English shipping company, which we said was responsible for the ship being sent to Chittagong, where it knew it would cause environmental damage and be dismantled in an extremely unsafe way with very unsafe working conditions. The ship that Mr. Molla was working on had previously been owned by companies within a multi-billion-dollar group headquartered in Greece. And one company within this group was Marin UK Limited, which is based in London. The sale was brokered in London and the ship was sold for demolition in a deal worth $16 million US. The buyer of the ship was a brass plate company. This company was registered in the Caribbean and the sale was guaranteed by a cash buyer. So you can see this is an example of the complexity of these commercial arrangements and the way that companies try to distance themselves from what is going to happen to the ship and that they know will be the conditions the workers are working under. So we brought the claim in the UK courts, and in 2020, the defendant applied for the case to be thrown out. So the defendant was arguing that it was too distanced from Mr. Molla's death to owe him a duty of care, and that his death was caused instead by the unsafe working practices at the yard, which they had no control over. So the High Court, which first heard the defendant's application, the judgment that was handed down involved the judge finding that it was arguable that the defendant had acted in a way that had exposed Mr. Moller to a foreseeable risk of death or injury, which was enough to allow the case to continue on to the next stage. But the defendant appealed this decision, and so the case was heard by the Court of Appeal in the UK last year. Again, luckily, the court dismissed the defendant's appeal and found that a shipping company in England selling a ship for dismantling in South Asia could owe a duty of care to ship-breaking workers, even where there are multiple third parties involved in the transaction. So the judges found that Marine UK could and should have insisted on the sale to a green yard where the proper working practices were in place. So just in terms of implications, this is a really important judgment as it shows that the courts are taking note of the risks and dangers inherent in shipbreaking and are prepared to scrutinise established practices within the shipping industry. And not only does it mean that it will be easier for similar cases to be brought in the UK and in other countries, it will also lead to increased international scrutiny of environmental and health and safety practices across this and also similar sectors. So the case has had significant developments in English law, mainly involving where an asset was sold and a defendant had nothing to do with the poor health and safety practices in the yard or in any other context involved with that asset. This is not a barrier to potential liability of that defendant. And just to finish off, we hope that the implications will be much broader than the maritime sector. It could lead to accountability of any company that seeks to distance itself from human rights and environmental abuses occurring elsewhere in its supply chain. And we've already seen some changes in the industry. So shortly after the judgment, there were reports that cruise ship owners may be willing to take a financial hit in order to comply with EU laws by selecting recycling for their ships. So we hope that these positive impacts will continue.
Thank you very much, Rachel. And both the presentations of Miriam and Rachel together show the potential of seeking judicial remedies abroad. So not in every case that is maybe possible. Again, there has to be some funding, the case has to be strong, and the challenges were highlighted already by both of them. But I think that avenue definitely is there and something for people in the room to explore, and of course those who are online as well, something to consider, that when we talk about access to remedy under Pillar 3 of the UN Guiding Principles, you need not just look at the options within Bangladesh or within South Asia. You can also look at the options outside in a creative way, in a collaborative manner. Now, moving from judicial options of seeking remedy internationally, I would like now to invite, last but not the least, Speaker Shankar, who would share with us a case study from Nepal. So we are covering different countries. And the case study, Shankar, I would like you to talk about is the indigenous people's rights when you try to approach the grievance mechanism of International Financial Corporation. So again, why did you decide to approach this grievance mechanism? What were the barriers you experienced? Outcomes, are you satisfied with it? Or any quick reflections if you can provide? Thank you very much. You have the floor.
Thank you very much, Professor Suryadeva, and thank you very much for having me here at this very important panel. And I agree with the panelists, their presentation, that those were very important and very lesson learning. Directly that my organization's Lawyers Association for Human Rights of Nepalese Indigenous Peoples, which is working for defending the rights of indigenous peoples in Nepal. And then we work based upon the request of the communities and the information provided them that how we can seek the remedies if there is their rights are violated in proper channels. So we are using national courts and also we are using National Human Rights Commission. At the same time, national remedial mechanisms in relation to addressing the indigenous people's right, specifically their rights is distinct. Not only their rights is distinct, but their problem is also distinct because they have been affected by the business activities disproportionately. And often that they are facing structural violence and also the historical injustices that is also relate in these kinds of activities that that may have like multiple consequences facing by the indigenous people. So that's why only going to the national court, which work in a very firm and strict rules and regulations and strict culture, that may not be sufficient to address the indigenous people's problems and indigenous people's right violations on the ground. And also approaching to the National Human Rights Commissions also may not be sufficient to raise all these kinds of issues within their jurisdictions. So that definitely we looked about the, especially the project which is funded by international financial institutions. They have the mechanism, what is called the accountability mechanism we can approach. Why we approach to this kinds of mechanism? It's quite open and it's less technical. Why I'm saying this less technical means that the communities or affected communities, they can approach and it's one of the example, for an example, let's see the ADB complaint mechanism. The community who have a problem to understand the national language, and that we cannot imagine about what about the English language. Also, language would be the barrier to for the access to or approach to the any complaint mechanism. So they can complain in their mother tongue, which makes more accessible to their complaint. That's the one thing. And another one, if we looked about the example of Nepal, though the indigenous peoples are constitutionally recognized and legally recognized, but when you bring the cases in the court, in de facto basis, that may not be, we can see in practice, or the court may not take how it has been incorporated or recognized within the constitutions and the law. That is the one of the challenge, right? So when we approach to this international financial mechanisms, mechanisms, if we complain there, then it will be more open. You can discuss about the indigenous people's rights, and indigenous people's, their voice can be heard, more accessible. So that's why it's quite lucrative to look about that one. And the another thing is that when you have to complain to the national court, then definitely you have to either go to the capital or you have to go to the district headquarters and the community living in the remote area. So that's why there is a the challenge that how the community can go there. And if the community have the the information about if they face these kinds of problems, if they are facing the injustices in their community due to the aggressive development activities, they can go to the court. No, that's not the case. But if you complain to these international mechanisms, they come to the community. That is the difference, right? So that's why. And another, as I mentioned about the technicality, let's say the court fee, and then you have to go to the court, and then you don't need to pay the court fee to go to the international financial institutions complaint mechanism, right? So that's why often, the compiling the complaint in this IFC complaint, then what will happen is the government, it drags the government or the government agency who is responsible to carry out the project to sit on the dialogue, meaning to say that if there are some kinds of discrepancies and there is a mistakes or error, it can be corrected. It can be reflected in an amicable manner, right? So that's why that we approach to international financial complaint mechanism. But there are challenges. Obviously, we have to say about that. If you file the complaint for an example, investigation panel of the World Bank, the investigation panel come up with a very good report. So what about the implementation? Right, that is always the challenge. That is there is one challenge, and another thing is it's also it's far from the community, and also we cannot imagine that going to the international level. Also, that is the challenge. Also, that we have to think about it. So to talk about the way forward, what we can do about that one. maybe we have to think about it. This international financial institutions complaint mechanisms, their jurisdiction should be expanded. Not only the community or the affected community brings the complaint and they act upon, but why not if they start from the very beginning? Suppose, for an example, if some borrower government is approaching to the financial institution, World Bank or ADB, why not this mechanism started talk about because they know obviously they have the the information that if that government where they are investing the money, whether in that country the indigenous peoples are not are existed or not, they know about that information. Nowadays it's very easy. So why don't they from the very beginning, rather than the waiting for the complaint, they started doing that one. So these kinds of human rights violation and abuses will not occur while operation of the project. So that's why I guess that will be the one of the way forward. And another one, when we talk about the human rights abuses by the business entities and business sectors, then we have like international standard UNGP, and also in relation to the indigenous peoples, they have like international standards UNDRIP, yes, United Nations Declaration on the Rights of Indigenous Peoples, which is a declaration adopted by all member states of the United Nations, right? So it is like a customary international law. So why not that has to be recognized in relation to the funding or the giving the loan or this whole things that has to be recognized in that. And some countries have ratified the ILO Convention 169 also, right? So that's why if these three instruments that has been recognized formally by these international financial institutions within their working area, not only reflecting these things in their report, but in the practice from the very beginning, if they recognize these all international instruments and work on that framework, maybe that the human rights abuses against indigenous peoples and local peoples, what they are facing because of this business operations and activities, that would from the very beginning it can be rectified or it can be avoided, or the business or development activities can be more sustainable, amicable, and human rights friendly. Thank you very much. I should stop here.
Thank you very much, Shankar, for highlighting the positive elements in terms of accessibility. If victims would like to approach the grievance mechanism of international financial institutions, I'm sure that would be a new piece of information for some of the participants, at least in this room or online. You also mentioned about a proposal how these grievance mechanisms could be proactive and deal with those grievances at the outset. So that is a welcome suggestion. Now we have about 15 minutes left. There's several questions in the chat box, and I would like to thank Sarah and Miriam for responding to those questions. This is very much appreciated. Because perhaps I may not be able to pick up all these questions. There may be some questions in the room as well. But I understand Madam Ukmi, she wanted to add something in relation to access to remedy. And if I may also ask you, because Sarah was talking about labor courts not being present in every district in Bangladesh, right? So the victims of labor rights abuses, they would have difficulties in accessing those courts. So whether the department is considering to establish those courts in every district. So if you can answer that question as well, but please be brief. Thank you.
Yes, thank you very much. I have to. Yeah.
Oh, okay. You can speak from podium. That's fine. But we are running short of time. So if you can be brief, that will be appreciated.
Thank you very much, all of the panelists. From the discussion of our honorable panelists, we are able to know about the legal proceedings and challenges of the existing law and implementation mechanism of different countries. as the question is related with access to remedy, already I have mentioned that it includes both judicial and industrial disputes when a settlement between the parties is not reached through mediation. But it is not possible to establish industrial or labor court each of the districts, as you know that in our country, a court is established on the basis of the number of the cases. So it is established on the basis of the cases, especially in the industrial zone, Dhaka, Chattogram, Khulna, Rajshahi, Borishal, as usual. And already 4 another courts are going to be established very soon. This is the reply of Minister Sarah Hussain. And another thing is which is related with commercial disputes. I want to mention that Law and Justice Division is going to establish 2 dedicated court which will adjudicate the commercial disputes, especially in Dhaka and Chittagong. And it is our plan that all of the cases which is related with commercial disputes, if we can adjudicate it before filing of the cases, then it will give a good result. So it is our plan in the sustainable development goals and with the alignment of 7th 5-year and 8th 5-year plan that we want to make a policy before filing of the courts. Each and every dispute have to be go for mediation, and before and after the failure of the mediation, anybody can file the suit. If we ensure this mechanism, then the number of the cases will be decreased and the applicant will get speedy remedy. So it is another mechanism. As you know that already our honorable panelist, Mr. Kamal Ahmed sir, mentioned that the non-judicial mechanism is related with Human Rights Commission, and already he has mentioned the measure of the Human Rights Commission. So you know that there are also environmental courts which decides claims for compensation for causing harm to the environment or biodiversity, imposing penalties. Moreover, under the leadership of our minister, the Law and Justice Division established the workers' legal aid cells in Dhaka and Chittagong, as I mentioned earlier, and to ensure protection and promotion of labor communities' legal right, we are going to strengthen the community mediation mechanism, and it is our planning to strengthen the community mediation mechanism as gender-friendly mechanism. So we think it will give a good remedy to the victims or the applicants. And another thing is, which already our division has arranged a program which was related to identify the gaps and challenges of existing legal aid process and how we can provide and strengthen our legal aid more in a quality manner. And from this learning, we are going to take the program of community mediation system. So these are all from our side, which already Minister Sarah Hussain has mentioned. I think she will take some important message from me. That's all from our ministry. Thank you. Thanks for patience hearing.
Thank you very much. This is very much appreciated. Now, Shankar, there are many questions, but Shankar, there are 2 questions perhaps I want to pose to you. One is about, the question is about that there is no clear definition of indigenous peoples in India. So if you have any suggestions on that, and because you also mentioned about the grievance mechanism of IFIs, I think there was a question that if the processes of these grievance mechanisms could be challenged before the national courts. You just have 2 minutes though, Shankar.
Thank you very much.
These 2 questions. Thank you.
Thank you very much. Obviously, the simultaneously we can go to the national court and international financial institutions, because we can bring up the issues in the international financial institutions complaint mechanism, which is quite open. So that's why there is no any kind of conflict. So that's why that's the one thing. Another, as I mentioned about briefly about the three instruments, ILO Convention 169, UN DRIP, and UNGP. I was referring to another way forward is indigenous peoples have a kind of offer for alternative dispute resolution, which is based on customary justice administration and justice system of indigenous peoples, which the community can be part of this whole process. If you looked about the court system and also the financial institutions complaint mechanism, the communities are almost isolated. They are like a recipient of the justice. No, that's not the truth. So if you go to the customary justice administration, community would be the part of this whole process. So I want to say about it. The second thing that in India, yes, of course, there is no single definition of indigenous peoples in international law, right? So except the Convention 169, it has a criteria. But it is well-known fact that indigenous peoples are identified, say they are self-identified people, and they are recognized either way, not directly referring to the indigenous peoples, giving them a status of the indigenous peoples. However, they are recognized as the distinct people. That means they are indigenous peoples. No need to define. My personal, the opinion is there is no need to define for the indigenous people. So the indigenous peoples, they can identify themselves, and the government has to recognize that is the core theme of the Convention 169, and that is the practice so far. So that's why even India does not recognize about the indigenous peoples. But I know that the Indian government has like 6th schedule and 5th schedule, and there are the laws relating to the indigenous peoples, and even the forest law that clearly recognized about the indigenous people. So I guess there is no problem about it.
Thank you. I just want to make a quick check in the room. Is there any question for the panelists in the room? I want to take one question. So I see one hand behind at the back of the room. Yes. And then I will take probably another question online. No, I see your hands. Thank you. Let me see how many questions I can take up. Can you be brief, please? Thank you.
Thank you, sir. I'm Shankar Limbu. I'm talking on behalf of indigenous peoples of Bangladesh. I'm a human rights defender. And my specific question goes to the Kamal Ahmed sir. I'm asking him that in case of Sahib Ghosh Bagda farm, it's a well-known case of Bangladesh as well as internationally, that indigenous Santals people are evicted from the land, and more 3 Santals shot dead. And is a case that where UNGP is failed by the government agencies as well as the law enforcement agencies, as well as the Sahib Ghosh Bagda farm, which is a state-backed sugarcane company. And we indigenous peoples, thanks to the National Human Rights Commission, they have made a tremendous support. They have arranged a public hearing, and they make the people who made the violations, they make them accountable. And we have also, thanks to the Bangladesh blast.
Can you please come to the question?
Yes, blast. Sorry. And everybody who have supported the litigation process of the indigenous peoples. And my specific question is that, sir, well, the case is still going on in the court, and the Police Bureau of Investigation and CID, they have made the probe report, and Santal have gave no confidence report on it. While the government also now taking the step to establish a special economic zone on that particular land of Santals. This is another mistakes of the government, that they have take a stand. And while the National Human Rights Commission earlier, they have made tremendous steps to handle the grievance mechanisms with the Santals and the government as well as the agencies. Now the National Human Rights Commission is silent. Why?
Kamalji, just 1 minute, because I want to take one more question.
Yes, you in your description, you have very nicely said that National Human Rights Commission supported it. Definitely, National Human Rights Commission supported. It is in the judicial domain, as a matter of fact, because these have, judicial process has started, but National Human Rights Commission took initiative to bring it to the awareness of the people, so that these people, Santals and others, are not deprived of their justice. That's why those have been taken into consideration. And another thing that you mentioned about setting industry in some places, that is also definitely free, prior and informed consent was necessary. Now, if that be the matter, definitely National Human Rights Commission will go forward and we'll talk about that. But if there is any judicial process, you understand that there cannot be, when it is matter sub judice, it has to go in that process. And my colleague also has very clearly mentioned about that. The judicial process will go on, but at the time of requirement, whatever the support is needed, National Human Rights Commission will definitely give it. Thank you.
Thank you for the response. Now we just have 4 minutes left, and I want to give 1 minute each. I'm sorry, to Sarah,
I have
Miriam,
one question.
and Rachel. Sorry.
I have one question, madam.
No, you have a question, but I suggest those questions can continue during a tea break, because I need to wind up.
Okay.
My sincere apologies, because I need to finish this 2:30. Then the tea break and next session has to start. I want to give 1 minute each to Miriam, Rachel, and Sarah. Either you can do any final reflections from your side, or you can quickly respond to one of the questions by anonymous attendee. Is about what burden of proof, discovery processes, and all those things are there. So if you want to respond to that question or any quick reflections, I will start with Sarah. Thank you.
Thank you so much. I think, the urgent thing for us is to see some outcome of some of our public interest litigation cases, which are asking for this change in terms of having effective remedies on the ground, particularly in terms of workplace deaths and injuries. We know there were dramatic changes after Rana Plaza, including in terms of the international coordination processes, but we have to see those changes effective in the national process. And for that, we really need protection for workers as well when they seek legal remedy. I think with the issues that are being raised about new due diligence requirements and so on, it will be very difficult to do those if it means that people providing information around lack of compliance at the local level face risks. They won't be able to provide the information. So I think we need to have a more open conversation and processes for that kind of monitoring and for access to justice.
Thank you, Sarah. So Sarah, are you hinting that the Bangladesh government should enact a law to protect those trade union leaders or others who may make complaints?
I think we need generally victim and witness protection laws and practices. We have them in the context of our war crimes legislation. We have some in the context of violence against women, but we need to see those being properly applied, and also in the context, I think, of workers' claims as well, because the risk factors are so high.
Rachel, your 1 minute. I'm sorry again, but if you want to make any reflections, final, thank you.
Thank you. Well, one thing that I just wanted to stress was that we can obviously do all we can from the UK, but one of the most important aspects of our work is working alongside organisations that are located in the country that we are bringing a case in. So in Bangladesh, for example, we've worked with some really excellent and inspiring NGOs and local organisations. And the work we do just wouldn't be possible with these people, without these people, both to give us access to people who might not be able to communicate with us or be nervous about their safety or reluctant to come through. It's building those relationships with the in-country organisations who in themselves have those relationships and respect and trust with the local communities. That's one of the most important aspects of our work.
Thank you, Rachel. Thank you for highlighting this relevance of collaboration and networking amongst lawyers and civil society organizations across the borders. Miriam, you have the last words. Thank you.
Sorry, thank you. Yes, thanks again for the opportunity to speak here. It's very good be here for online. Yes, I want to reiterate what Rachel has been saying. So I think collaboration is very important because we are talking about global production networks. And so while I do agree with all the speakers that local remedies are the most important aspect of this, we do need to look at the actors that are influencing and that are powerful, still located in Europe or in other countries. So that we need to really tackle all actors along production networks, because I think in the end, they all do influence what is happening on the ground.
Thank you very much, Miriam. So with this, I would like to conclude the session. So may I invite all the participants online or in room here to have a round of applause for our excellent panel of speakers. And my apologies once again that I could not take all the questions, but that shows the relevance of access to remedy. And I will encourage you to continue the conversation over the tea or coffee break. And I think the next session will start at 3 p.m. Dhaka time in about 30 minutes from now. No?
Thank you.
Oh, my apologies. The session will start in 15 minutes. 1-5, eh? 1-5. So it will start 2:45 Dhaka time. Thank you.